Hello friends, welcome to lesson 18, Compensation Legislation Act 1923, Main Provisions. Introduction. The labor legislations are the products of industrial revolution and they have come into being to take care of the peculiarities created by it. They are different from common legislations because they come to alleviate special disorders created by specific circumstances. Labor legislation regards individuals as workers, whereas the general legislation regards him a citizen. The principles governing labor legislations are more influenced by the postulates of social justice than the general justice. Workers are the weaker class of industrial society and have suffered long at the hands of employers. Therefore, these legislations protect workers and secure justice. The influences of discriminative justice and distributive justice can be clearly seen over them. All the labor legislations are heavily skewed towards labor and they are specifically designed like that. The main objectives of this lesson are, after the completion of this lesson, you will be able to understand the major provisions of Workers' Compensation Act 1923. Let us now begin to understand our lesson by discussing primarily the understanding the significance of labor legislation. Labor legislation seeks to deal with problems arising out of occupational status of the individual. Consequently, such problems as hours of work, wages, working conditions, trade unions, industrial disputes, etc. come to be the main subject matter of labor legislations. Under labor legislation, the individual is affected in the capacity of a worker or an employer. Labor law is also commonly known as the law of employment. The growth and development of labor laws can be traced back to the establishment of the International Labour Organization, the only tripartite UN agency in 1919. It brings together governments, employers and the workers of 187 member states to set labor standards, develop policies and devise programs promoting decent work for all women and men. It is devoted to promoting social justice and internationally recognized human and labor rights, pursuing its founding mission that social justice is essential to universal and lasting peace. India has been the permanent member of the governing body of ILO since 1922. This has been a major reason behind the progressive labor legislation in India. As labor legislations regulate the conditions of labor in the industrial milieu, it is required to be adjusted as per the changing requirements of the industry and society. This has to be done more frequently than the general legislation where changes are not that swift. Unless labor legislations are subjected to frequent revision and not left to continue as they are, they become obsolete and irrelevant. Social Security labor legislations. They cover those legislations which intend to provide to workmen social security benefits under certain contingencies of life and work, and under this the Workmen's Compensation Act 1923 amended in 2017 is covered. The other legislations as part of this are the Employees State Insurance Act 1948 amended in 2010, the Coal Mines PF Act 1948 which was amended in 1996 and the Employees PF and Miscellaneous Provisions Act 1952 and the Maternity Benefit Act 1961 which was amended in 2017 and Payment of Gratuity Act 1972. Friends, now let us begin our discussion about Workmen's Compensation Act 1923. Employees or Workers' Compensation Act 1923 is one of the most important social security laws. The Act's main aim is to provide financial protection and assistance to employees and their dependents through compensation in case of any accidental injury occurs during the course employment. It is generally applicable to the cases where such incidents lead to either death or disablement of the worker. The Act was formed after it was noted that laborers were getting more exposed to danger with the use of advanced and sophisticated machinery. The common law had it that the employer would only take up the compensation responsibility if it is found that the industrial accident was a result of his negligence. In India, the issue of compensating workmen after fatal and major accidents hit the road in 1884. It was then in 1885 that the Factory and Mining Inspectors realized that the Fatal Accidents Act 1885 was not enough to attend to the intended purposes. The state offered a hearing ear when members of the Legislative Assembly, employers' representatives, workers and experts in medicine and insurance formed a committee that gave a report that led to the enactment of the Workmen's Compensation Act in 1923. Before 2010, Employees Compensation Act 1923 was known as Workmen's Compensation Act. It provides for compensation to an employee who dies or suffers partial or total disablement due to accident on duty. The compensation has to be paid by the employers. An employee cannot claim compensation under the Act if he or she is already entitled to compensation from ESIC. Let us now try to understand the important principles governing compensation. There are two basic concepts of the Act: the theory of minimum cost and the theory of including the cost of the workman's efforts into the cost of production. There are various resources used to run an industry like machinery, capital, skilled and unskilled workers. Every industry keep aside a certain amount for any mishappening that may occur in the factory. For example, a machine does not work properly, a wall of an industry falls, etc. So, a question arises, if the machine gets such concerns, then why not humans? A major concern with regard to compensation is who will be receiving the compensation on behalf of the deceased. The Act provides for these people who can receive compensation on behalf of the deceased. A widow or a minor who is a legitimate son or unmarried daughter or a widowed mother is entitled to compensation. If the family of the deceased is wholly dependent on the earnings of the employee at the time of his or her death, or a son or daughter who has attained the age of 18 years. A widower, a parent other than a widowed mother, a minor illegitimate son, an unmarried illegitimate daughter, or a daughter legitimate or illegitimate or adopted if married and a minor, or if widowed and a minor. A minor brother or an unmarried sister or a widowed sister if a minor, a widowed daughter-in-law, a minor child of a predeceased son, a minor child of a predeceased daughter where no parent of the child is alive, or a paternal grandparent if no parent of the employee is alive. Let us now discuss the important provisions with regard to the applicability of the Act. It applies to all employees working in mines, factories, plantations, construction establishments, oil fields, etc. Moreover, it applies to establishments which are under Schedule 2 of the Workers' Compensation Act. The Act applies to persons who are working abroad or outside India as per Schedule 2 of the Act. It applies to a person recruited as the mechanic, helper, driver, etc. in connection with a motor vehicle. It also applies to a captain or members of the crew of an aircraft. Moreover, the Act does not cover the members of armed forces who are already under ESI, that is Employees State Insurance Act. Section 3 of the Employees Compensation Act deals with employers' liability for compensation. This section provides the conditions when an employer is liable to pay compensation to the employees. Let us now try to identify the cases where the employer have to pay. Firstly, injury by accident during employment. Secondly, diseases in occupation. If the injury is an occupational disease mentioned under Part A, Part B or Part C of the Schedule 3 of the Employees Compensation Act, the disease should have been caused due to an injury by accident during employment. The Act provides that compensation is provided to employees and their dependents only if the injuries from the accident includes occupational diseases. The accident must occur in the course of employment. The Act also applies to railway servants and the persons employed in any such capacity as specified in the Schedule 2 of the Employees Compensation Act. The people employed in factories, mines, plantations, vehicles, construction workers and certain other hazardous occupations come under Schedule 2. A fatal accident is one where there is death or a high risk of loss of life of the employee. In the case of a fatal accident, the employee might die or suffer severe disablements and injuries. On the other hand, non-fatal accidents are those accidents that do not have a high probability of death. In the case of non-fatal accidents, the employee or the workman might suffer disabilities or any type of personal injury. Both fatal and non-fatal accidents are covered by the Employees Compensation Policy, provided such accidents result in the mentioned contingencies in the Act. Fatal accidents are taken as those which I just mentioned, which result in death or permanent total disablement, permanent partial disablement or fatal injuries. If any of these contingencies occur, the Employees Compensation Policy would pay the claim faced by the company. In case of non-fatal accidents though, the covered contingencies might not occur. The employee or worker might not face any type of disablement or injury from such accidents. If the employee or workman suffers from a type of disablement and the disablement does not last for more than 3 days, the claim would not be paid. As a result, in several employees' compensation policies, non-fatal accidents are usually not covered unless they cause a disablement which lasts for more than 3 days. Notional extension of employer's premises. When there is a causal connection between the accident and the place where the employee is working, compensation is payable for the disability or death of the person according to the Employees Compensation Act. This is the doctrine of notional extension of workplace. The theory of this doctrine was executed in some cases, for example, Mundra and Company versus Master Bhavani. There was a truck driver who was told by his employer to drive a petrol tanker. The driver found a leak in the tank and sought permission from the employer to look for the source of the leakage. While searching, he lit a matchstick and the tank caught fire. The driver received burn injuries and died. It was held by the court that the family members of the deceased would be entitled to compensation since the accident took place at the workplace and in the course of employment. There are also cases where the employer do not have to pay. What are those cases? In case of any injury or damage which does not lead to semi or total disablement of the workers for a period exceeding 3 days. In case of an injury which does not result in death or permanent total disablement under these circumstances. The workman present at the time of the work under the control of drunk or drugs. When the worker deliberately disobeys the rule which ensures their safety, non-application of the devices which are especially for the safety of the workers. Doctrine of added peril. When an employee performs something which is not required in his or her duty and which involves extra danger, the employer cannot be held liable to pay compensation for the injuries caused. In the case of Devi Dayal Raliyaram versus Secretary of State, it was ruled that the doctrine of added peril was used as defense and the employer was not liable for compensation. When it comes to adjudication of compensation, the adjudication is done by the commissioner in calculation of the amount of compensation. The quantum of compensation is calculated from the date of the accident. In the cases of self-inflicted injury, if a worker inflicts an injury to himself or herself, it is a self-inflicted injury. The injury may be intentional or accidental, but the employer is not liable for such injuries. Contributory negligence. Employees owe a duty to their employers to carry out their work with reasonable care so as to avoid accidents and injury. Employers are vicariously liable for the negligence of their employees but are entitled to claim a contribution or indemnity from the negligent employee in appropriate circumstances. So, if there is a negligence on the part of both employee and the employer, then the employer will be liable to pay compensation to the extent of his own negligence, not of the employee. Hence, the compensation amount may reduce as the employer will not be liable for the negligence of the employee. Let us now try to understand what is the procedure to claim compensation. The process to claim the compensation includes these aspects. The applicant has to either give notice to the employer or enter it in the notice book within an appropriate period. The notice should incorporate the name and address of the person injured, including the cause of injury and the date of injury. Submit the claim application to the commissioner within 2 years from the accident date. In case of occupational disease, the accident gets considered to occur on the first date when the illness occurs. With regard to compensation calculation, the computation of the compensation under the Act is done as per the provisions of section 4 of the Act. In case of accidents resulting in death, an amount equal to 50% of the monthly wages of the deceased multiplied by the relevant factor or an amount of rupees 1,20,000, whichever is more. If the accident results in permanent total disablement, an amount equal to 60% of the monthly wages of the injured employee multiplied by the relevant factor or rupees 1,20,000, whichever is more. In case of permanent partial disablement, such injuries are dealt with under Part 2 of Schedule 1 of the Act. In such a case, compensation percentage payable gets specified as the percentage of the loss of earning capacity caused by the injury. If in any case Schedule 1 of the Act does not mention the injury, the compensation gets calculated as the total disability in proportion to the loss of earning capacity. In case of temporary disablement, an amount equal to the half monthly payment equal to 25% of the employee's monthly wages. The central government has changed the amount of wages to be considered for calculation of compensation to workers under the Employees Compensation Act 1923 Wide Notification SO 71E dated 3rd January 2020. The amount of wages considered previously for the calculation of compensation was just rupees 8,000. Now it is rupees 15,000 according to the notification by the Ministry of Labour and Employment. The relevant factor for computation is mentioned in Schedule 4 of the Act. The Employee Compensation Amendment Act 2017 amends the Workmen's Compensation Act 1923, which provides for payment of compensation to the workmen and their dependents in the case of injury or death by industrial accidents. The Act applies to a specified group of people such as those employed in factories, mines and plantations. The Act substitutes the word workman with employee so that the law is applicable to all types of employees and is gender neutral. It also amends Schedule 2 to increase the list of persons who are included in the definition of workmen. For example, the Act only included those people who were employed in repairing or altering any article in a place with more than 20 employees. The Act includes all persons employed in such work by omitting the requirement that the place should have 20 employees. The compensation to employees in case of injury or death is a percentage of their monthly wage or a specified amount, whichever is more. The Act increases the specified amount in case of death from rupees 80,000 to rupees 1,20,000. In case of permanent disablement, the amount is increased from rupees 90,000 to rupees 1,40,000. The Act allows the central government to revise the monthly wage from time to time. The employee shall be reimbursed for any medical expense incurred for the treatment of injuries during the course of employment. The funeral expense of the deceased workman has been increased from rupees 2,500 to rupees 5,000. It also allows the central government to modify the amount from time to time. The state government may appoint any person to be a commissioner for the workmen's compensation. The Act stipulates that the person should be a member of a state judicial service for a minimum of 5 years or an advocate or pleader for a minimum of 5 years or a gazetted officer with minimum of 5 years service having educational qualification and experience in personnel management or human resource development and industrial development. The Commissioner shall dispose of cases related to compensation within a period of 3 months from the date of reference. The other significant provisions of the Act is Section 20, which mentions about the appointment of Commissioner. Commissioner means a commissioner for employee compensation appointed under Section 20. The state government or the central government may appoint any person to be commissioner for Workmen's or Employees Compensation Act in some specified areas. Every commissioner is identified as a public servant in the Indian Penal Code. The section 29 of the Act deals with the effect of failure to register agreement. The employer will be liable to pay the full amount of compensation if the registration of the agreement of memorandum is not sent to the commissioner as required under the section. The employer will pay the compensation as he is liable to pay under the provisions of the Act under section 4 until the commissioner directs to deduct more than half of the amount to be paid to the employee as compensation. Let us now have a quick look at the workers' insurance policy. The workers' insurance policy ensures protection of labor from exploitation and any injury caused at the workplace. This labor insurance has its importance in the lives of the labor working in factories and industries. The workmen's compensation insurance for employees protects the employee and their dependents in case of any mishappening at their workplace leading to death or permanent injury or any other temporary injury which occurred while performing the functions while at workplace. Such insurance bears the cost of treatment of permanent disablement or death that occurs during employment. The employee gets the benefit of the compensation in most cases other than when it was the fault of the employee himself. The workmen compensation policy ensures that the employee gets good quality medical care and also it provides the part of income that the employee loses. At the same time, he is not able to work. In case if the employee dies suddenly, then the benefit of the policy is given to the employee's family. The workmen compensation policy covers situations that lead to a medical emergency such as bodily injury that occurred during the duty, death benefits to the family of the employee and disability due to injury, legal expenses if it gets incurred with the consent of the company. However, it does not include an injury that does not cause partial disablement of more than 3 days, an injury caused under the influence of drugs or alcohol, psychiatric diseases, non-fatal diseases and employees not considered under workmen under the Employees Compensation Act. Friends, let us now summarize this lesson. The labor legislations are the products of industrial revolution and they have come into being to take care of the peculiarities created by it. They are different from common legislations because they come to alleviate special disorders created by specific circumstances. The principles of labor legislation have been categorized as social justice, social welfare, national economy and international solidarity. Employees or Workers' Compensation Act 1923 is one of the most important social security laws or legislations. The Act's main aim is to provide financial protection and assistance to employees and their dependents through compensation in case of any accidental injury occurs during the course of employment. Thank you.